SJC-13758 in the matter of an impounded case.
Okay, Attorney Krasner.
Good morning. May it please the court. My name is Sherry Krasner, and I represent the child. The three appellants, father, mother, and the child, appreciate that the single justice of the appeals court put this case on an expedited track and that this court put it on an even faster track. We ask that it remain on that course as you deliberate. My client came into care when he was 2 days old. That was 268 days ago. We understand that the safety of my client will be at the fore when you decide this case. And my sister counsel will discuss how information can and should have been shared when a parent with a protective history in Massachusetts moves to another state. But in my time, I'm asking the court to laser focus on two statutes, Chapter 119 and Chapter 209B, because as a matter of statutory construction, this court must enter an order of dismissal based on a lack of subject matter jurisdiction. There's a threshold jurisdictional requirement in Chapter 119 for care and protection cases. Section 1 talks about the purpose of the care and protection litigation to protect children of the Commonwealth. And while that term is not expressly defined, I don't think there is much wiggle room with respect to legislative intent. And importantly, there's nothing in Chapter 209B that contradicts or undercuts Chapter 119. In fact, the two statutes can be read very much in sync. The introductory language of Section 2A of 209B makes it clear that preliminarily, the Massachusetts court must be competent to hear child custody cases. And the competency is that it involves a child of the Commonwealth. In our case, we suggest there are absolutely no metrics under which my client could have been considered a child of the Commonwealth. His circumstances are factually and therefore legally distinguishable from the two appeals court decisions concerning jurisdiction over newborns born outside of Massachusetts. The published case of adoption of Anisha, which Justice Katzker authored, and the unpublished decision, adoption of Raphael. My client was born in a Connecticut hospital to two parents, each of whom were living in Connecticut. In fact, when DCF provided the Massachusetts judge with the Connecticut addresses in the filing affidavit upon which it relied to obtain immediate ex parte custody. This is very different from Anisha, who just happened to be born in New Hampshire.
I agree it's different than Anisha, but we do have other states. How you treat a newborn child in a hospital is not completely clear, right? The cases, Anisha distinguishes when you're just sort of passing through in another state. But
correct.
What do we do here? This child's a newborn in a hospital. There are some cases out there, I think at Montana, I can't remember, there are a couple of them that say that we don't treat a child in a hospital as that being their home state, right? It kind of gets unclear.
Right. But let's look at the facts. Both mother and father were.
I can see the parent issue is not the one that I find the most complicated. It's the child when it's a 24-hour-old child. Right. Yeah.
But for the actions of Massachusetts in coming across the border and seizing the child, the child would have been a Connecticut child. I mean, that's the circumstance that makes the question a question. And
can you go backwards to the point that I think you were making to begin with, which is, I think you were talking about the authority of the department here over, quote unquote, a child of the Commonwealth, which seems to me a distinct question from the operation of the statute governing jurisdiction. And are you relying on the argument that, can you explain, I think we're here on a question about the court's jurisdiction, are we not? So can you explain how that relates to the question, the child of the Commonwealth question? Because the jurisdictional statute provides different language about whether the child, the home state, which is a sort of overlapping but different question.
And if I understand your question correctly, are you saying why aren't we looking first at 209B to establish jurisdiction?
My question is should we use this child of the Commonwealth standard to supplant the home state inquiry?
I think the child of the Commonwealth is the threshold question, 119, whether the juvenile court can even hear the case and adjudicate whether a child is in need of care and protection. And they can do that. They have a statutory grant of authority to adjudicate a child in need of protection, but only if it is a child who is a child.
But isn't that contradicted by the jurisdictional statute that contemplates that if there's a terrible emergency with a child who is just passing through Massachusetts, that there is jurisdiction in the court?
Well, again in 119, but in section 24, it talks about filing petitions on behalf of children within the jurisdiction. So I think that section allows for that circumstance when there is an emergency, that the court can preliminarily at least make a determination. And that child, by virtue of being in the Commonwealth, is a child of the Commonwealth.
Everyone agrees that this child doesn't meet that definition, right? The emergency one, both sides agreed is not applicable.
Correct, correct.
Okay, so
Either under section 24 or under.
And you're fighting over the home state issue or the third category, right?
The fourth.
The fourth category, right. So your view is, okay, Connecticut is the home state.
Correct.
And therefore, although Connecticut has a different statute than we do, Connecticut has a different statute than we do, right? But I take it your argument is Connecticut statute, this kid he was in Connecticut, his parents were there for a couple of months at least, so it's the home state. So that kind of ends this for you, right?
Correct. Although I'm arguing that preliminarily, we don't even get to that 209B because my client wasn't a child of the Commonwealth under 119.
It's kind of a chicken or an egg issue, though. Yeah.
Address the 209B. It's almost for us belt and suspenders because the way that both trial judges looked at it was under 209B, and they failed to look at that threshold requirement.
Can you explain in your view what should have happened in a situation where the department had reason to believe that a person about whom they had tremendous concern had purposefully absconded from the Commonwealth so that the department would not take measures to protect the infant?
Certainly, and I don't want to steal thunder from my sister counsel who was going to address this, but remember in this case that the Massachusetts DCF did speak to Connecticut DCF, but that conversation occurred before the child was even born. And of course, at that point, Connecticut, we have no interest in a case in which a child has not yet been born, but there certainly are ways that there could have been that communication after the birth of the child. There are statutes, 11951E, 51F, and regulations 110 CMR 12.078 and 10. There are ways that information can be shared. There are standing orders in the juvenile court that there can be requests for transcripts of proceedings. There are all sorts of ways, contrary to what Judge Shaw says in her findings. There are ways that that information could have been shared at the birth of the child and
in a way that would have been sufficiently expeditious?
Yeah, certainly.
And then second question, what is your view as to if we were to agree that there was no jurisdiction as of August 28th of last year. What is your view of what should happen now where the infant has been in the care of people in Massachusetts for that entire time?
Certainly. Well, we do believe that that there is no option but to dismiss because the court never had jurisdiction. And in that 28-day period after an order issues from this court, there can and should be communication between the Massachusetts DCF and Connecticut DCF. I mean, I want my client to be safe. I mean, that's not, we need to assume that, of course, that's what I want. But there are ways that that information can be shared were this court to enter an order of dismissal. I see that my time is up, and I thank the court.
Thank you. Okay, Attorney Bench.
Good morning. I'm Nathan Bench. I represent the appellant mother in this matter. I did want to address Justice Kafkar's question about how we treat infants in the hospital, especially given the case law in which other states have answered this question. And I want to address at the same time DCF's argument that the brief period from the child's birth to removal cannot constitute living with, as defined in 209B Section 1, for the purposes of finding home state of a child less than 6 months old.
Keep your voice up, please.
Oh, sorry. Yeah. Is there a way to?
Yeah, you can push it up.
Thank you. I'm less familiar with this arena. Thank you. So Section 209B, Section 1, defines a child's home state, an infant's home state, less than 6 months, as the state in which they lived from birth with a parent in that state. And DCF's interpretation would have hospitals become a gray area where even a child born in Massachusetts to a Massachusetts resident or
I
domiciliary.
think their argument is much narrower. It's what Justice Stewart was pointing out. You've got the combination that the child's 24 hours old and this finding by the judge that she's in Connecticut to avoid Massachusetts. That's the intersection. And that's the harder question, right? That in the cases I don't think are very clear on whether that child's home state is Connecticut or Massachusetts.
Certainly, and I would point out that in the two Massachusetts cases on point, one of the focuses was, I believe it's Gill versus Zervisio, that states that the child's domicile is the domicile of the parents. And here we have numerous findings made by Judge Dunbar, finding specifically 39, 42, 46, 49, 52, and 70, that talk about all the connections that mother and father had with Connecticut. Mother had moved and was residing in a shelter in Connecticut. Mother had Husky insurance. Mother was involved in services and therapy in Connecticut, prenatal appointments in Connecticut, and of course the child was born in a Connecticut hospital before being removed. And importantly, before the petition and after the petition was filed, that child remained in the Connecticut hospital and was receiving care in that Connecticut hospital. And so the connections here are much more significant and legally significant to the interpretation of both the child of the Commonwealth argument and the 209B analysis. And I would also state that those two are largely consistent, and in many cases, we see the same principles involving jurisdiction in both the 119 argument that we put forward as well as 209B.
So what is the relationship in your view between jurisdiction under 119 and jurisdiction under 209B? Is one a predicate to the other? Do they both need to be satisfied? Is it enough if one is satisfied? What is the relationship between those two?
As Attorney Krasner stated, 119 is a threshold issue. Within 119, there's already limitations on, a child, right? What the definition of a child is. We don't have a care and protection for a 19-year-old or 20-year-old in Massachusetts. Likewise, Massachusetts doesn't recognize fetal personhood. And so there's already kind of a limitation built in within 119. And we are suggesting that within care and protection cases, that threshold issue should be analyzed before 209B, which the legislative intent was to avoid disputes between different jurisdictions having a claim to the same custody
I'm confused
case.
on that.
Yeah.
So if the child is, everything's in Massachusetts, and then right before the birth, the parents know that they're trying to avoid DCF, and they run to cross the border to the closest hospital to have the baby. Are you saying that we don't have, it's not a child of the Commonwealth?
I think if those were the facts of the case, that would be Anisha.
Yeah, that's why I'm bothered by what you're arguing.
So what I'm arguing is that mother established domicile. We have sufficient facts for that.
Separate question, though, but I think we've been asking the question, you keep trying to say that 119 is a threshold and somehow provides a stricter jurisdictional standard based on the fact that the child is in the Commonwealth. I don't know where that comes from. Isn't it the same standard under 209B and 119?
I think it is a similar standard. My understanding is, I think that if we go back in time to when the care and protection petition was filed, if a judge looks at the care and protection petition and what we have is addresses in a different state, so established residences in a different state, a child who, but for state action, was in a different state, I think that should be a huge red flag jurisdictionally. That should, put the lights on.
Under both.
Under both, certainly. And definitely,
So is it the case that Chapter 119, Child of the Commonwealth, is defined by 209, Section 2?
I think that could be a reasonable interpretation.
So that's what we're trying to get to, I think, is the various questions. How do these two seemingly different standards actually read together? And I'd posit to you, and I wonder if you would agree, that a child of the Commonwealth is a child of the Commonwealth if under the 1 through 4, the Commonwealth retains jurisdiction.
I think generally they are largely consistent. I think there can be cases, and this is not one of them, where it could be that it is not a child of the Commonwealth, but jurisdiction could be manufactured under the MCCJA. And in this case, again, the child's home state's not Massachusetts. The child lacks a significant connection with the Commonwealth. And I would say that the only significant connection that Judge Shaw found at the end of her findings was a single, the siblings who are in the Commonwealth. And I would posit the question to this court, if the mere fact that there are relatives in a state were a significant connection, when would the Commonwealth not have appropriate forum jurisdiction in a case such as this, where there are parents with a history with the Department of Children and Families?
Do you agree with your sister's recommendation about dismissal?
Yes.
So if we found that this should have proceeded in Connecticut, what's our order read? It says the case is dismissed and what? That the child goes to where? And by the way, do the record, the parents, I don't know where they still live in Connecticut?
Yes.
Okay.
There were, because, the single justice reopened the evidence, there was continued evidence that mother remained in Connecticut long after.
Can I ask one other question? Mm-hmm. Can we discern from this record, if you have Husky Connecticut insurance, does that mean you do not have Massachusetts health insurance, or do we not know that from this?
I don't believe that's clear from the record. I think it is implied, strongly implied, that when you have one, you may not have the other. and it is a requirement to have Connecticut residents to have Husky insurance.
And this may be perhaps overly technical, but I am very interested about the remedy, if we were to agree with your position on the merits. Are you taking the position that there's no jurisdiction in this court over this appeal? I don't think so, correct?
No.
So it wouldn't be about dismissing the appeal.
No.
It would be about remanding it with an order to the Probate and Family Court to dismiss the underlying care and protection action.
That's correct.
And so when the reference was to the 28 days, I take it it's the 28 days between the issuance of a decision here and the rescript?
Correct.
And your position is during that 28 days, the parties somehow would be able to initiate some sort of communication with Connecticut?
Yeah, and there is strong record evidence of this. In the last few jurisdiction conferences, the area program manager for DCF mentioned that they were in contact with a Connecticut DCF in the locale, and that they were ready to take the case if there was an order of dismissal. Likewise, the Judge Anker, the Connecticut judge who declined jurisdiction, stated on the record that a significant change in circumstances in this case would be an order of dismissal of the lower court's jurisdiction, based on the lower court's jurisdiction. And she likewise said that would change her decision to decline jurisdiction. I think things were, someone mentioned chicken before the egg. I think that happened in this case in that what was presented to Connecticut wasn't, would you like to take jurisdiction? It's, we have jurisdiction, we've got all this evidence here, when in fact there was no underlying basis for jurisdiction in the first place under either 119 or 209B.
Okay.
I'm over
Yeah,
time.
thank
Thank you
you.
very much.
Okay, Attorney Chenevert.
Good morning, Your Honors. May it please the court. My name is Dana Chenevert, and I represent the father. There's a lot I want to get into with what my brother and sister weren't able to flesh out completely with this court. But before I do that, as for my client, the record is clear that he is this child's legal father. There's no dispute about that. Judge Dunbar found that my client was a resident of Willimantic, Connecticut at the time that the child was removed. That's a finding that is not, it's not challenged by the department. So what we have here is a unit, the entire family unit is a Connecticut family. This is a Connecticut family. The record supports that. There's no time limitation in either 119 or 209B that would require the mother to be a resident of Connecticut for any particular amount of time. And I think that this is what raised the brow of the single justice upon receiving the findings of the first judge who heard the evidence at the temporary custody hearing, that there was no affidavit filed, but then the mother had not resided in Connecticut for 6 months. That is not a requirement. That is not a thing. What should have happened in this case, I would like to address Justice Stewart's question. What should have happened? Let's go back to law school. Let's issue spot. With the petition that was filed, there were red flags all over that thing. The parents had Connecticut addresses. This child was born in a Connecticut hospital. That should have raised the question of when the department came and filed the petition pursuant to Chapter 119.
If I could just interrupt you, I think I understood Justice Stewart's question, and of course she can speak for herself, but this is my curiosity. What should have happened, what does DCF do with the information that they have about this mother's long history when she's now moved to Connecticut? That, to me, that would be interesting.
Yes. And that's part of what should have happened.
Not about what the court should do, subject matter jurisdiction, but
okay.
there's a child involved, and the
Sure.
child is potentially in danger imminently. What should have occurred? What should have DCF done?
DCF should have reached out to its counterparts in Connecticut, the social workers in Connecticut DCF, not the hotline worker, not the person who answers the phone when you call AT&T Wireless and say, I have something wrong with my phone. They should have called the Department of Children and Families in Connecticut. We have statutory construct, we have regulations, we have case law that supports that they can share information. They could share the case file. They could share the affidavit, the 51B, the investigation. This is supported by Chapter 11951, Sections 51E and F. Their regulations, 110 CMR 12.07 and 12.08. They have lots of ways.
So there were options for DCF to have shared the information about their concerns with
Absolutely.
Connecticut DCF and have Connecticut DCF do their investigation and intervene as needed.
Absolutely. They had many, many choices.
Thank you.
They
So-
did reach out in some limited way, didn't they, beforehand, besides that emergency phone call? Because everyone was on notice to do something, so there had been some contact, right?
There had been contact. The Department of Children and Family Social Worker, the supervisor, Cavallari, she presented herself at the hospital the day before Mother was induced. And she had a conversation with that hospital social worker. She shared information informally, without any court order, without any request. She shared information with this social worker, and this is why the hospital knew to call the DCF hotline when the child was born. That was the instruction by the DCF social worker, the supervisor. Please call us when this child is born. And that is what happened before the child was born. There could have been an...
Just to clarify the facts, there wasn't a call from DCF to its counterpart in Connecticut prior to that showing up at the hospital the day before?
That's correct, Justice Kafka. What DCF is saying that they did, their efforts, respectfully, is we called the hotline, the Connecticut, the equivalent of the Judge Baker hotline in Massachusetts. That's what they did in Connecticut. And they reached a person. They didn't know the testimony at the testimony from the area program manager revealed that they didn't know who they talked to. They couldn't remember the name of the person who answered the phone. This was not a person that had any authority, I would say there's a reasonable inference, who had any authority to accept or decline or take action at all on this case. This is a person, and when that person acquiesced, that was DCF's, this is what they own as they gave us permission, or they declined, or they deferred to us. That hotline didn't defer to them. They did not have authority to do this. So information share, they had lots of options there. So what?
But we're not actually reviewing that, correct? What we're reviewing in this appeal is whether the probate and family court had jurisdiction over the initial care and protection action and issuing that, had the jurisdiction to issue the temporary order. Is that correct?
That's correct,
Okay.
Justice Wolahojian. And we posit that it did not, under any section. Under 119, they filed the petition under 119, Section 24. And when we talk about this language, child of the Commonwealth, it is defined. If you read some of these statutes together, we have Chapter 218, Sections 57 and 60. I don't have my readers on, so this is going to be difficult for me to see. But the language provides, within the territorial limits prescribed in Section 57, the divisions of the Juvenile Court Department shall have and exercise jurisdiction over cases of juvenile offenders under age 17 and cases of neglected or delinquent children. Now, Section 57 defines the territorial limits as the various counties in Massachusetts. Now, our court did not have jurisdiction over this case because this child was not within the jurisdictional limits as prescribed by Chapter 218, Sections 57 and 60. This child, before being brought here by the Department of Children and Families, born in the Connecticut hospital, had not set foot in any of these counties. This court did not have jurisdiction under 119, or 218, Sections 57 and 60. Now, 119, Section 24, that language is also pertinent. It says, and this Section 119, this governs the filing of care and protection petitions, and this is what I was trying to get at earlier, Justice Winland, is that at the time this petition was filed under Section 119, or Section 24, this court, it says, a person may petition under oath the juvenile court, alleging on behalf of a child within its jurisdiction that the child is without necessary and proper physical educational care. You know, you can do this, but the point, the relevant part of this statute is that on behalf of a child within its jurisdiction. This child was not within this court's jurisdiction when it was born in a Connecticut hospital to parents who were Connecticut domiciliaries. This court should not even, when they received that petition, we should have looked at the statute and said, this is not our child. But keeping in mind, you know, we don't want this court to leave this session thinking that this child is in danger and that Connecticut is ill-equipped to take care of its native children. That's simply not the case. We go back to the information share. What DCF could do or could have done, let's call Connecticut. And we have to, it does not endanger a child to require Massachusetts to honor the jurisdictional boundaries and allow Connecticut to take care of its own while we take care of our own. It does not endanger this child. So under Section 124, the lower court never had jurisdiction. If we had sincere concerns, and we know that the record is, it's not pretty, there are concerns, but they needed to have been addressed in another way, in a different way. So the relief,
I'm sorry. You're over time. And
I'm sorry, yes.
No, it's okay. I think you said.
I was going to
basically-
wrap up.
Yeah.
Yep. So that said, we would just like this court to reverse the denial of the motion to dismiss for lack of subject matter jurisdiction and order any other, and then I'd rest on our brief. If there are no further questions, thank you, Your Honor.
Thank you. Okay, Attorney Gallup.
May it please the court, Julie Gallup, on behalf of the Department of Children and Families. The department determined that this child was in danger. Given the limited information that we had about the parents, whether they had any supplies for an infant, the department was aware of a very serious incident of domestic violence where father threatened to murder
So
mother.
why does the court have jurisdiction? I mean, I understand that there were serious concerns. Why does this court have jurisdiction, not this court?
Initially, the court
Judicial
had
Juvenile Court.
jurisdiction under default jurisdiction because the child has no home state. Now, to respond to Justice Kafker's question to my sister, one of the first questions about whether you can say lived with, how do we interpret lived with? The department, in its brief, cites to an Illinois case. It's, I believe, in Ray DS or RL, one of the two, but it's the Illinois case, where they look at the definition of lived. Does it mean to be alive, or does it mean to occupy a home with a parent? And they found it was the latter.
But that case was factually very dissimilar because it was a situation where the person had fled just before birth. They weren't even intending to be in that state. I think were headed for Tennessee or somewhere else. They were in transit, whereas here, at the relevant time in August of 2024, it was known that mother had signed up for Husky, was in a shelter in Connecticut, and had been there since at least April 1st, as of the birth in July. So do you have a case that is it all factually similar to that?
The closest case, I would say, would be the two cases, adoption of Anisha and the unpublished case, adoption of Raphael. Quite frankly, you cannot live with a parent by staying in a hospital
No, but usually the domicile of the child is the domicile of the parents, and here the parents both were domiciled in Connecticut and gave birth to this child in Connecticut.
The department had not yet confirmed mother's address.
But
with
it
the
doesn't
shelter.
matter what you confirm or don't confirm. The question is a legal issue, whether the home state of a child to two Connecticut residents who is born in Connecticut is a Connecticut child, if that's, if that's the home state of the child.
I would suggest that the Illinois case is instructive. Now, the facts may.
But that difference is huge, right? Because in that case, Illinois, I guess it was Illinois, was not the domicile of the parents.
The same thing with Anisha, right?
So to allow a temporary hospital stay to confer
But
home
it's
state
not,
jurisdiction.
it's not just the temporary hospital stay. It's the
It's-
domicile of the parents together with the birth of the child in that state.
The point, well, with regard to the UCCJEA, and I would say also with the MCC, the Massachusetts Child Custody Jurisdiction Act, you want the court that is most equipped to address custody and has the most information. The
But
court
why
that-
can't, is there something wrong with the Connecticut court? It's not equipped to handle this information?
I'm speaking about with regard to the emergency that the department saw at the time when the child was in the hospital, was aware of two parents who had not yet confirmed either address. It was the department's understanding that father was homeless. He was moving between Massachusetts and Connecticut. On the petition itself, it does list, I think, homeless. I don't know if it says homeless/Connecticut. So where the department needed to act to protect this child.
Well, they could have gone into court in Connecticut, right? There's a process where DCF is an interested party, right? It can go into Connecticut court the day this child's born and alert the DCF people in Connecticut. And then this could be litigated in Connecticut where both parents live, where the child was born, and you don't have to cross the border to take the kid, right? You can
So
protect the child, but just not take the child out of Connecticut and
That-
take, I mean, right? I mean, it just seems, if they're all living there, this is the exact opposite of Anisha and that Illinois thing.
So I think factually speaking, the department had contact with mother on July 22nd, and that had been the first contact it had had with mother since April. And on July 22nd, she told the department that she was due sometime in August, when she was in fact scheduled to be induced 3 days later. So the department was working with the information that it had at the
I
time,
totally agree. The
and
department.
it was an emergency.
I agree that there's an emergency, and I agree that the department can't sit on its hands because this child needs attention. But the question is where and who has jurisdiction to decide. And we normally don't run across borders and take kids, do we?
Well, I mean, I think that this is a rather novel case, is that there were only those two other cases that I could find that were, relatively.
I want to try to see if my understanding about something is correct. I don't see this case, but straighten me out if you disagree with me, as requiring us to opine upon what DCF could have done, did do, should have done, or the reasonableness of that. I see it as the question as to whether when DCF filed its care and protection proceeding in a Massachusetts probate and family court, whether that Massachusetts probate and family court had jurisdiction on the over the care and protection proceeding. Is that correct?
That's my understanding, except it was the juvenile court.
Oh, juvenile court, I'm so sorry. All right, so if that, and that seems to me is, I think everybody who's argued today seems to agree with that proposition, that probably it looks like there were grave concerns about the safety of this child, but that this juvenile court was not the right place for care and protection proceeding. DCF should have gone somewhere else. So if that's, accepting that, I have a second question, which is about your position on hospitalization. Are you taking the position that any child born in a hospital is stateless, has no home state, as a matter of law? Because that sort of sounds to me as though you're taking that position.
I would say that if the child is removed from the parent's custody in the hospital, the existence on this planet from birth to the point of removal cannot confer home state jurisdiction because the child has not lived with a parent in the Commonwealth, as in lived in a home with.
Doesn't it depend upon, as the judge found, that the parents are transient, basically?
I think it's important to note that the department had the information that it had at the time. It was acting on an emergency basis, and as the juvenile court determined, it was aware when we filed the petition that the child continued to be in the hospital in Connecticut. And on that basis, on the basis of mother's 22-year history with us, determined. Now, it was not completely articulated at that point when the petition issued, but that there was default jurisdiction due to the substantial evidence and significant connection, and that child had no home state. I don't know if I'm answering your question.
But if she had no home state,
I'm stuck on Justice Wall.
she has no home state, why? Because she was born in a hospital? If she had been born, if the mother hadn't gone to the hospital and had the birth in her domicile in Connecticut, would this child have had no home state?
I'm saying that I guess I would say by virtue of the department's actions, the child had no home state when the petition was filed.
So the department's removal action is what made the child
Well, because he was never
stateless?
discharged from the hospital with the parents.
The department provided its own jurisdiction.
The department assumed emergency custody through Chapter 11951B, and then so that was at 4:30 p.m. on a Sunday. The next day, went to the juvenile court, filed the petition, made the judge aware that the child still continued to be in the hospital, and at that point, the judge issued the precept and, temporary custody to the department. That was the jurisdictional piece.
So if a parent had a troubling history with a parent in Massachusetts, and the parent then was transient and gave birth in Oklahoma, you could fly to Oklahoma and have jurisdiction over the child?
Yes.
Okay.
What's your best case for that? Oh, you already answered that. You said Anisha.
Is it the exercise of emergency jurisdiction that, in your view, is giving you that hook, that hook?
I would say that, so I think that the department's exercise of jurisdiction under Chapter 119 is completely separate from the juvenile court's authority to enter custody orders. So the department assumed emergency custody based on the danger that it determined to the child at the
Right,
time.
and that first issue is not before us.
Correct.
Right.
And
So the only issue before us is the juvenile court jurisdiction.
correct.
Yeah.
So
why does the juvenile court have jurisdiction over a Connecticut child?
because the judge determined that the child had no home state, never lived in a home.
But that's circular. That's a legal question, and that's before us. Why does this child not have a home state?
Because the definition of home state is for a child under 6 months where the child has lived with a parent or person acting as a parent from birth until, the date of whatever type of case is being filed.
And you're saying that DCF can affect that legal analysis by, given the rightful concerns that DCF had, going to Oklahoma and declaring this is our child under emergency custody.
But that's separate from the juvenile court's authority. So
No, but it's part of the home state jurisdiction.
Right. You gotta meet one of the 4 criteria. And just when you miss the home state's only the first step.
right. So
Just because, even if we buy into your view that their child doesn't have a home state, which I'm not sure we do, you still wouldn't have jurisdiction. You got to meet one of the other three.
Correct.
And
So.
you don't meet the emergency one because the child's not in the Commonwealth.
So I would argue that we had the juvenile court determined default jurisdiction based on significant connection that both the mother and the child have to the Commonwealth and substantial evidence that exists here.
What's the child's connection?
I would argue that the child has, at the time that the petition was filed, 2 of his older half-siblings remained in the department's custody in Massachusetts, and he had an older half-adult sibling who also lived in Massachusetts.
And you balance that against the fact that the child's mother and father are in Connecticut.
Purposefully to avoid the department and the juvenile court's intervention.
Yeah, that's the only issue that really provides complication to this. It's whether that, given that fact finding, because otherwise, Connecticut clearly has jurisdiction over this child. So there's not no other state that can do this. It's obvious that there's another state where the child is in, where the parents are in and residing, and where the child and the parents have health insurance. Yeah, so it seems to be.
I mean, I guess this would be a statutory interpretation of what does lived with mean. Again, does it mean to just be alive, or does it mean to occupy a home and establish connections?
Thing. Connecticut probably meets multiple equivalencies. The child is there. There's an emergency. Even if there wasn't a home state because of this running away issue, there's probably emergency jurisdiction in Connecticut, right?
So under the circumstances, the juvenile court then did, because jurisdiction was being contested, it scheduled further hearings with the competent court in Connecticut to determine whether that court.
After it exercises jurisdiction, it tells the court, do you want it or not? I mean, again, cart before the horse, right?
I mean, some of the cases talk about that at the, jurisdiction might not be immediately clear at the outset of a case, and that it may take a judge some time to determine whether, how, what is going on in this case. And
So wouldn't it have made more sense to take no position on jurisdiction and say, let me puzzle through this, and rather than go into it with Connecticut and say, I've already done something, would you like to do something next? Say, I don't know what to do, and hold it open and have a conversation about where the appropriate forum should be.
so it's my understanding that the department had the information it had at the time. It reached out to Connecticut DCF and made it aware of the circumstances that there was a parent at the hospital or was about to.
No, I'm talking about the judge. I'm not talking about you guys. I'm talking about the judge here in Massachusetts, not exercising emergency jurisdiction, holding the matter open, and then doing something more prudent and say, let me reach out to my Connecticut counterpart and let's have a hearing, rather than making this determination, which essentially puts a thumb on the scale.
So then I guess that would leave the child in the maternity ward at the hospital pending all of those further hearings.
Is that such a bad thing?
I mean, I
A newborn
don't.
child being in a maternity ward in the hospital after just having been born, that's a bad thing?
I think that the facts were that, if I'm recalling correctly, that he was ready to be discharged from the hospital. So, now we have an infant living for several weeks in a maternity ward.
Chief, may I ask a question? It's the same question I had for everyone else, and that is, assume that we were to conclude that the juvenile court did not have jurisdiction over the care and protection action, couldn't enter the temporary order. What, in your view, is the appropriate relief at this point? Because I believe everyone in this courtroom shares the same concern about making sure that the child is safe and someone gets to take a look at that.
I believe 209B, Section 7, appropriate forum jurisdiction, discusses the different steps that can be taken. So, you can put the case, stay the case, and I guess there would be some sort of, I believe it is in the record at one of those jurisdictional further hearings that there was an interstate compact homesteading performed on mother by Connecticut DCF that was denied. So it would then be requiring, I would assume, for,
Denied because the child is in DCF's custody, or?
no,
why?
denied because of mother's history of losing all custody of all her older children and the,
So they weren't going to do a home study of the parent? I'm confused. You better, is that in the record, by the
it's
way?
it's in the record that there was an ICPC home study.
So we would issue a decision here that says juvenile court did not have jurisdiction, and then what else would there be in there, if anything?
I would suggest potentially that the matter would be stayed and information would then need to be communicated to Connecticut DCF.
What authority would we have to order a court with no subject matter jurisdiction to stay anything? It literally has no authority over the thing.
No, maybe perhaps you're suggesting that the issuance of the rescript would be stayed?
Yeah, I'm talking about in terms of like if the court determined that the juvenile court acted inappropriately, that what we could do would be to transfer information to Connecticut, have them file a case, and
Okay, do you see any reason why that couldn't happen in the period, the 28 days between the issuance of the decision and the issuance of the rescript?
I don't think I could answer that question
Okay.
in a helpful way.